Today we're going to discuss Chapter 10, which is pretrial and jury trials in America. Essentially, the disposition, plea, bargaining, trial, and sentencing. Criminal courts have several important decision points that determine how justice is meted out. The initial one is plea bargaining, and then trial, and then for those cases that go forward, sentencing. Now, some of this I know is mentioned in Chapter 1 in the overview of the system, but we're going to get into a little bit more depth for this chapter. We talk about plea bargaining. We're not concerned with determining guilt or innocence. In fact, all it does is allows the defendant and the prosecution, particularly it's the prosecution, remember from the last audio, prosecution really has unfettered discretion, that they are the ones that are most in charge. It allows the defendant and the prosecution to efficiently determine the amount of punishment without the expense of a jury trial. And that really is the entire goal of plea bargaining, is to try and get clear dockets, court dockets. So a vertical plea is by pleading guilty or nolo contendere to a lesser included charge, the defendant can reduce the potential for what would maybe be a harsh sentence. If we did a horizontal plea, they will plead guilty to a charge in exchange for other charges being dropped. Recall me talking about the prosecutor will sometimes overcharge in anticipation of being able to drop other charges. Now, plea bargaining is there's also a reduced sentence plea where the prosecutor, defense attorney, and judge might decide on a reduced sentence. Operative word here is might. It is not always a guarantee that the judge will accept the plea bargain. Avoidance of stigma plea, so the defendant pleads guilty to a lesser charge to avoid the more serious charge that might carry a stigma. So sometimes maybe sex offenders, or if this is an individual that is an outstanding citizen but has been charged with multiple crimes, they could reduce the stigma and potentially give him or her a less charge or ask them to plea bargain. So the fundamental issues, we're going to talk about presumption of factual guilt, cost and risks of the trial, and what to do, in fact, with the guilty. So pretrial release is a tiny bit different than when we're talking about plea bargaining. So this is before the proceeding to trial. The issue of releasing the suspect must be addressed. So some folks can stay, be held, detained. We'll talk about bail in a minute. Some folks can actually go home pending pretrial. So pretrial is exactly what it is, before trial, okay? At issue are sometimes conflicting rights of the accused to be free before trial and the need of the state to protect citizens from the accused prior to the trial. So pretrial release factors, often prosecutors will look at the nature of the crime as well as the offender, look at the offender's criminal background, look at their cooperation, look at the impact on the community if they were let out pre-trial, and then sometimes, not always, will consider the victim's opinion. So to allow folks to come out pre-trial, we have to make sure that they'll come back. And so what we do is have money or some other security provided to the court to ensure the appearance of the defendant. And so what that is called is bail. And so all bail is the purpose to obtain pretrial release from a person charged with a crime. That's it. It doesn't establish guilt. It doesn't do anything else. It's just simply saying that we believe this individual is a good candidate to be released pre-trial and that they will in fact show up for their trial at a later date. So there's non-financial forms of pretrial release. ROR on the left is release on your own recognizance. So this is a form of release where the defendant just simply promises to appear for trial. Nothing's put up, no money put in. It's just simply saying that you're a decent citizen, seems like you're an outstanding citizen, doesn't seem like there'll be any victim safety if we release you. So you sign a piece of paper, you say, yep, I'll show up, and then we say, see you later, make sure you show up. Now, the Manhattan Bail Project in New York found that verified information concerning character and roots in the community of the defendant. So residence mattered. So did you have an established residence? Employment mattered. Did you have established employment? Relatives in the area mattered. So were you going to, somebody would help tell us if you ended up going away. Prior record matters. So what happened to you before? What did you do prior to this time in for your other court cases? Did you show up to trial? If so, then it's likely that you'll show up again. So another non-financial form, so RRR is one, and then the other one is a conditional release. And so this is saying that we have a lot of non-monetary conditions that can be imposed. And so one is just maintain your residence and employment. Pardon me, and that would be your status quo conditions. Another would be restrictive. So we would say, okay, at a certain time, you're going to have curfew. And then contact conditions that you would maybe have to report to your probation once a week, once every week, maybe have to do a UA, urinary analysis, something like that, to pee in a cup to make sure that you are not doing drugs or drinking alcohol. And then we have conditions of problem-oriented conditions like drug or alcohol treatment. And so another non-financial form, so we have RRR, we have conditions, and now we have third-party custody. This is often for juveniles. This is where a judge will assign custody of the defendant to an individual who promises that on behalf of that defendant that they'll come to court. So a juvenile defendant may be released to the custody of their parents. So, is there a right to bail? The amendment does not guarantee a right to bail. All it guarantees is no excessive bail. So it's all that is no excessive bail. So it doesn't say that you have a right to bail. It just simply says if bail is going to be offered, it can't be excessive. So now we're going to talk about financial types. One is cash, and so the defendant pays the entire amount in cash, and that's returned if they show up in court. Doesn't matter if they've been adjudicated guilty. We don't care about guilt. All we care about is you're going to show up to court for pretrial. Another type of financial is property. Do you have something to hold up that the court can be held in as collateral? Now, the courts clearly are not real estate agents or anything like that, so they're not looking to collect anything, but they're just simply saying that if you don't show up to court, we will use your collateral and go ahead and cash in on that house, and then more than likely they'll sell it later. There's private security bail. Private organization or person will post the full amount. The bail is returned again as long as they show up. Deposit bail, this happens a lot. So the defendant pays a percentage of bail amount to the court. Again, it's returned if the defendant appears in court. Surety bail, so this is where they pay a percentage of the amount to a bonding agent who posts the full amount. So the fee is not returned to the defendant because that's the surety agent. Your bonding agent is the person that's going to take that fee, but the courts don't take it, but the bonding agent does because they're saying, well, we put up money for you. And then unsecured, this is non-financial. So those were financial. And then unsecured bail, the defendant makes no payment at the time of at the release. And then again, if they don't come to court, then they'll issue a warrant for their arrest. So some criticize because they say that it discriminates against poor. So again, if you don't have cash, you can't put up full cash. If you don't have cash, you can't put up a percentage. And if you don't have cash, you often probably don't have a house. So it's impossible to possible to discriminate against poor defendants. It's impossible to translate risk of flight and danger into dollar values. And so the idea that money so just because you have $10,000 put on your head to come to court doesn't necessarily mean that you're going to actually come to court. Premise that money will secure appearance, again, is questionable. The judge may set the bail too high, then that's what we would call preventative detention. Now, if it's, again, that's against the Constitution. Your right to bail is not against it, but excessive bail is. Transfer bail decisions from the judge to the bail bondsman. So now the bail bondsman is able to maybe come to your plea and be able to, for an amount of money, be able to put up money for you. So now that's taking decisions from the judge now to the bail bondsman if they were willing to support you. Provides little or no supervision. So again, all the bail is just simply saying that we'll release you and that you're going to show up to court. Informally punishes the poor, yep. Discriminates against racial minorities, perhaps, and then fosters abuse and corrupt practices, again, for mainly bonding agents that are in it for the money. And so even though there are a lot of criticisms of pretrial, it is a beast that we need because we can't hold everybody. And so the courts try to figure out, are we going to release a rapist? Are we going to release an armed robber? So they'll look at your crim history and they will look to see how committed you are to the community and things like that. So the pretrial phase of the trial, initially you do motions. These are for dismissal of charges. Motion for continuance. A continuance is just that you want to hear it at another time. Motion for discovery, that you want to know what the other side has. What sort of documents do they have? Motions for severance of defendants as well as severance of offenses. So this, and then suppression of evidence. So the idea that if something is illegal, they don't want that to be seen. Motion to determine competency. Is somebody have the cognition to be able to stand in court and understand what's happening? And the motion for change of venue. The fact that somebody believes that they will not have a fair trial if they stay in the certain neighborhood. And then at the trial, then you have opening arguments. The prosecution goes first. This is a crime against the state. No evidence is presented, and then the defense counters the prosecution. And then you have presentation of witnesses and evidence. And so the prosecution begins, and the defense can cross-examine, and then the prosecution can re-examine if necessary. And then the defense can re-cross-examination. Defense presents evidence and witnesses in summation. And so the interesting thing about when you're looking at a trial is the individual that is the the victim is often called a prosecuting witness, a PW. And all that PW means is that you're one piece of information in that whole trial. So a victim would say, well, this happened to me. Let's say a sexual assault happened directly to me. It is now a crime against the state, and your representation is a piece of the entire event, not everything. So sometimes witnesses or prosecuting witnesses or victims get mad because what they want to happen doesn't happen, but the prosecution or the state would say it's a crime against the state. They're going to do what's best for the state. So do all misdemeanor and felony have a right to jury trial? The U.S. Constitution has been silent, but the Supreme Court has not. In 1968, Duncan versus Louisiana, the Supreme Court said that the Sixth Amendment is applicable to state government when the defendant is accused of a serious crime. Again, we've heard this a couple ago with law enforcement. And then Baldwin in 1970, the Supreme Court ruled defendants have the constitutional right to jury trial in all cases if the individuals facing a prison sentence of 6 months or more. And so it's evolved over time. Jury trials are those which members of the community evaluate facts to determine if the government has established legal guilt. And so when we look at legal guilt, this is a guilt beyond, again, you'll hear this from the law enforcement chapters, guilt beyond for criminal trial, guilt beyond a reasonable doubt. And then absence of legal guilt means a person is not guilty. So what does this mean? Well, proof beyond a reasonable doubt would be 7.5 on a scale of 10, that a reasonable person with common sense would be able to agree with you. It's not, it's substantial, that the doubt would cause a prudent person, again, a reasonable person, to hesitate before acting in a manner of importance to themselves. The jury is a panel of citizens selected according to law and sworn to determine matters of fact in the criminal case and to deliver a verdict of guilty or non-guilty. So the jury size could be either between 6 and 12. And so 12 jurors are required in all federal cases and in all capital punishment cases. So capital punishment is death penalty cases. The prosecution has to say on the front of a case whether they're seeking the death penalty for the client or for the alleged defendant, and so if they are, they have to have 12 jurors on the front end. So the question was raised in Williams versus Florida in 1970: is 6 jurors sufficient, and does it deprive a defendant to a constitutional right by a trial jury, their jury? And in fact, the Williams versus Florida said yes, that you can actually use 6. So in a 6-person verdict, it has to be unanimous. In a 12-person jury, it has to be, in the federal system, it has to have a unanimous. Capital trial has to have unanimous, and all but 2 states have a unanimous vote. Louisiana and Oregon say that it can be a 10-2 majority rule, so it doesn't have to be unanimous. Who can serve on a jury? So you have to be a citizen, 18 years of age, residents in the jurisdiction of where the jury is being called, have ordinary intelligence, and be conversant in the English language. You cannot serve on a jury if you're a convicted felon, if you served in the last year, if you establish an occupational hardship for the court to say why you don't want to serve on the jury, and then folks under 18. And then often they will exclude help-seeking occupations like fire, police, and then legislatures. How do we select a jury? So we have 100 to 1,000 citizens summoned for a jury period. Often it's looked at if voter registration. So if you vote, you'll get called. Do you have a driver's license in the state? You might get called. Are you a welfare recipient? You might get called. Are you on unemployment payroll? You might get called. Do you have a property? So property tax assessments might call you. Telephone directory, not so much anymore because cell phones, it's really hard for us to track them. And then utility users. So as far as selecting a jury, so we have the jury pool, and then we have 50 people that are selected randomly for a specific case, and then voir dire, 35% of them are challenged or returned back to the jury pool to be used at a later time. 15 are selected for jury, 3 are selected as alternates, and then 12 people are seated as actual jurors. And so when you're establishing the jury, you can do challenge for cause. And so this is to determine if someone is unfit to serve. The prosecution and defense want someone who is sympathetic to their side. The judge and both sides actually ask questions. So the prosecution asks sides, the defense asks sides, and then the judge will ask questions. I'm sorry, not ask sides, ask questions. And the number of challenges is limited. It can't go on and on. And so preemptory challenge allows for attorneys to excuse jurors for no particular reason. They don't have to disclose. However, these preemptory challenges are limited, and they cannot be used to blatantly eliminate jurors based on the basis of race, ethnicity, or gender. In Georgia versus McCollum, 1992, the Supreme Court ruled the defense may not exclude a person based on their race or ethnicity. And then we have in Jebb versus Alabama, the Supreme Court also ruled neither prosecution nor defense could exclude based on gender. So here's the thing, my friends, that, we say not based on gender nor race, as long as it's not blatant. If it's subversive, then we don't know that that's why people are being excluded. So what do we know about juries? Jury trials are longer. They slow down the process to clear the docket. Longer sentences are normally associated with trials, and men are normally more dominant in jury deliberation. So this longer sentences are normally associated with jury trials rather than bench trials or even a plea bargain. So that's one of the things that prosecutors will do is say, okay, so I'm going to make sure that I'll use a jury trial and get you, in front of the jury to, use a plea bargain so that you don't take up the court's cases. And the idea is that if you take a plea bargain, then you might not have a longer sentence that you would if you did take up the court case, the court's time, and went towards a bench or jury trial. Only 5% of cases are heard by jury trial, so that just is telling you that a lot of cases are heard from plea bargain, because again, they try and clear the docket. In the jury's absence, the judge becomes the trier arbitrator of truth. Judges versus juries, they don't always evaluate evidence in the same way. Juries will look at the nature of the victim, the act, and whether the defendant took the stand, where the judge is more versed at what happens in a courtroom, so he or she might look differently at that evidence. So preventative detention. Some say that deny pretrial. So based on the notion that certain offenders will commit crime, folks that are in favor of preventative detention say don't release them. So society has the right to be protected from future criminal acts. Those are folks that say yes to not release folks for preventative detention. So deny them bail, not offer them bail. Others say that if you do preventative detention on the base of what they did in the past, you don't know what's going to happen in the future, that this is a form of punishment, which is not based on a guilty verdict, and it's something that might happen. So there's definitely some controversy around whether or not we should use preventative detention. So like I said, almost 90% of all convictions are plea bargain. And you already know that it's the interactive process between the prosecution and the defense without going to trial. So the guilty plea is the most common plea. Judge must inform the accused of A, their loss of rights, and B, their right to counsel, and then consequences and possible sentences. And the judge has to establish that the plea is actually voluntary. Types of plea bargains: there's charge bargaining, reduction of initial charges, reduction bargaining, reduction in the number of charges, sentence, recommendation for a lighter sentence, altering charges to alter the charges to a more socially accepted one. So, for example, sexual assault or rape can be reduced down to a GSI, and that's called a gross sexual imposition. So GSI looks better on someone's history than a rape or sexual assault. And then judge shopping. Sometimes defense attorneys will recommend for their clients to make sure that they take a plea bargain in front of some judges than to go to a jury trial in front of others. So factors affecting the plea decision of plea bargain, again, the nature and offense, defendant's prior age and prior record and their age, the strength and admissibility of the evidence, attitude of the complainant, and then prosecutors in areas with low population are more likely to bargain. So the good thing is that it reduces costs, it improves efficiency, it concentrates on serious cases, it could avoid pretrial detention and delays because they are plea bargaining and so they're out immediately. Others would say that it encourages defendants to waive their constitutional rights. It results in lesser sentences and, in fact, sentencing disparity because people are having to plead guilty to charges that they might normally not have pled to, but they have been convinced that they'll get a lesser charge to go ahead and plea bargain. And again, it may coerce innocent to plead guilty. So reform plea bargaining, folks would want to make it more visible, understandable for their clients or alleged defendants, and also fair. To do that, they would need to create specific guidelines, require judicial supervision over the process, and place limits on the process.